the Department of Justice officially surrendered. Lawyers representing the former administration notified the federal court they were completely dropping their appeals, openly admitting defeat in a massive legal battle over executive directives designed to punish their political enemies. They waved the white flag and packed their bags. Then, precisely 1 day later, an unseen force made them rip up that surrender and file a 97-page legal document that reads exactly like an unhinged social media rant published at 2 in the morning. This sudden reversal exposes a deeply compromised institution experiencing a public meltdown. The federal court system just witnessed one of the most embarrassing displays of legal whiplash in modern history. The attorneys representing the highest levels of the government were forced to argue that federal judges have absolutely no right to restrict the executive branch in any capacity. They claimed the courts cannot dictate what the commander-in-chief says, who the administration investigates, or how the government handles national security clearances, even when those powers are blatantly weaponized to target independent law firms. This was not a carefully crafted legal strategy grounded in constitutional precedent. This was raw, unfiltered panic. The premier law enforcement agency in the land effectively transformed into a personal defense firm. They desperately submitted a nearly 100-page tantrum right after officially admitting they possessed no winning argument. They knew they stood no chance against the independent legal professionals who refused to submit to absolute authority. Yet, they marched right back into the courtroom to blindly defend a massive overreach of executive power. This dramatic turnaround is not simply about poor legal writing or humiliating courtroom tactics. It reveals the exact moment the structural integrity of the justice system fractured under intense political pressure. We are watching the real-time consequences of a leadership style that demands absolute loyalty over the rule of law. The stark contrast between the professionals who defended the Constitution and those who surrendered to the intimidation tactics is the actual story buried inside this massive legal filing. Hello everyone and welcome to United States News Daily. We break down the complex legal and political battles shaping our nation so you know exactly what is happening behind closed doors. If you appreciate this kind of deep dive into the facts, please consider subscribing to the channel and turning on notifications so you never miss an update. Now, we need to examine the specific firms that fought back and the ones that folded completely. The court documents reveal a brutal dividing line within the elite legal community. On one side of this invisible boundary stood 4 distinct entities. On the exact opposite side, 9 others made a completely different calculation. The 97-page legal tantrum actually performs one incredibly useful public service. Hidden deep within the dense legal jargon, specifically buried inside Footnote 1, is a permanent historical record of who held their ground and who surrendered their lunch money to the neighborhood bully without throwing a single punch. We must first recognize the 4 legal powerhouses that refused to bend the knee. These are the democracy's most valuable players. Perkins Coie, Jenner, and Block, Wilmer Cutler, Pickering, Hale and Dorr, and Sussman Godfrey looked at the executive orders designed to intimidate them, evaluated the threat to their operations, and chose to fight back. They took the commander-in-chief to court and they won. Their victory was not just about protecting their own corporate interests or shielding their wealthy clients. By standing tall against a blatant abuse of office, they effectively created a massive protective shield for every single legal professional operating in the United States. They proved that the executive branch does not possess unchecked imperial power to punish attorneys who happen to represent causes or individuals that the administration personally dislikes. When the federal government threatened to suspend security clearances, restrict access to federal buildings, and force government contractors to publicly disclose their affiliations with these specific firms, these 4 institutions did not blink. They recognized the outright lawlessness of the directives. They understood that if the highest office in the land could successfully weaponize the federal bureaucracy to bankrupt or paralyze opposing legal counsel, the entire foundation of the adversarial justice system would collapse. Their refusal to back down was a masterclass in holding the line for democratic norms. The narrative takes a dark and profoundly disappointing turn when we examine the rest of the document. The exact same legal filing that inadvertently highlights the courage of those 4 firms also permanently exposes the cowardice of 9 others. The government lawyers explicitly noted that 9 entities recognized the so-called problems identified by the administration and agreed to address their practices. They voluntarily committed to providing free legal work to serve the specific public interest defined by the very same administration that was threatening them. Translating that from sanitized legal phrasing into plain reality reveals a shocking capitulation. 9 of the most powerful, resource-rich legal institutions on the planet crawled into the Oval Office on their bellies. They looked at the exact same unconstitutional executive overreach that the brave 4 defeated, and they chose absolute submission. The document lists the members of this footnote of shame clearly: Allen and Overy, Shearman and Sterling, Cadwallader Wickersham and Taft, Kirkland and Ellis, Latham and Watkins, Milbank, Paul Weiss Rifkind Wharton and Garrison, Simpson Thatcher and Bartlett, Skadden Arp Slate Marr and Flom, and Wilkie Farr and Gallagher. These are not small, struggling practices desperately trying to keep their doors open. These are massive, globally recognized titans of the legal industry. They possess limitless financial resources and harbor some of the most brilliant legal minds of this generation. Yet, when faced with an authoritarian pressure tactic, they completely folded. Their decision to surrender carries devastating, long-term consequences that extend far beyond their own boardrooms. By agreeing to change their internal practices and dedicate free labor to appease an angry executive branch, they actively rewarded the abuse of power. They sent a crystal-clear message to the administration that intimidation tactics work perfectly. When powerful entities give in to unlawful demands simply to avoid a public conflict or a temporary loss of government contracts, they embolden the abuser. They provide a dangerous validation to the idea that the rule of law is negotiable if the person making the threats holds enough political leverage. The submission of these 9 titans created a massive chilling effect across the entire legal landscape. If the biggest players in the game are willing to sacrifice their independence to keep the administration happy, a mid-sized firm or a solo practitioner has absolutely no hope when the government turns its hostile gaze in their direction. The actions of the Cowardly 9 essentially drafted a blueprint for future administrations to successfully coerce the private sector. They prove that you do not actually need sound legal footing to control your enemies. You only need to exert enough pressure until the target calculates that fighting back is simply too exhausting. This historical record, perfectly preserved in the government and APO's own desperate court filing, serves as a permanent testament to both the resilience and the extreme fragility of the American legal system. The contrast could not be more severe. The 4 victorious firms defended the constitutional rights of the citizens by refusing to compromise their integrity. The 9 capitulating firms endangered everyone by demonstrating that absolute power can successfully extort compliance from the private sector. They traded the foundational principles of justice for short-term institutional comfort, leaving a permanent stain on their reputations that no amount of corporate public relations can ever erase. The actual text contained within those 97 pages represents a spectacular departure from traditional legal reasoning. The government attorneys explicitly declared that the judicial branch possesses absolutely zero authority to dictate or restrict the actions of the chief executive in this matter. They wrote, in formal court documents, that courts cannot tell the president what to say, nor can they tell the president what not to say. They further asserted with total confidence that the judiciary cannot interfere with how the administration handles national security clearances, regulates government building access, or reviews federal contracts. This specific framing fundamentally misunderstands, or perhaps intentionally ignores, the basic architecture of the American Republic. The Founding Fathers designed a complex system of checks and balances specifically to prevent the exact scenario these government lawyers were aggressively defending. The entire foundational purpose of the federal judiciary is to review the actions of the executive and legislative branches to ensure they comply strictly with the Constitution. By arguing that presidential directives regarding security clearances and facility access are entirely immune from judicial oversight, the department was effectively arguing for the establishment of an absolute monarchy. When a sitting president uses official government powers to target private businesses simply because he dislikes their political affiliations or the specific clients they choose to represent, that is not a calculated national security decision. That is textbook, undeniable retaliation. Reading through the sprawling document feels significantly less like reviewing a serious legal argument, and much more like reading a dictated, deeply personal grievance. The brief actually accuses the lower court judges of bending over backwards to facial invalidate the executive orders. This is a highly unusual, profoundly disrespectful, and deeply unprofessional tone to take against federal judges. The absurdity of this accusation becomes even more glaring when you consider that the magistrates who ruled against the administration were appointed by presidents from both major political parties. The partisan nature and vindictive intent of the orders were so painfully obvious that conservative and liberal judges alike found them entirely unconstitutional. Yet, the attorneys signed their names to a massive document claiming these independent judges were simply encroaching on executive power. For generations, the attorneys working within this specific federal department took immense professional pride in their written work product. They were widely considered the most elite, highly principled lawyers in the nation, tasked with representing the collective interests of the American people. Their historical briefs were heavily researched, meticulously cited, and grounded in solid, undeniable legal precedent. The document currently under our review abandons absolutely all of those historical standards. It swaps rigorous constitutional analysis for breathless, dramatic political rhetoric. The transformation of the institution is truly staggering to witness. The premier law enforcement agency was effectively converted into a taxpayer-funded personal defense firm, entirely focused on justifying the personal vendettas of the commander-in-chief. The authors of the brief attempted to mask their ultimate, authoritarian goals behind the noble veil of addressing racial discrimination and protecting national security. They claimed the executive orders were absolutely necessary to instruct federal agencies to investigate violations of civil rights laws. However, the courts saw right through this incredibly thin, deceptive veneer. The true, undeniable intention was to financially punish entities that refused to align with the specific political ideology of the administration. When government attorneys deliberately twist the language of civil rights to defend the aggressive suppression of private businesses, they degrade and insult the very laws they swore an oath to uphold. Furthermore, the brief attempts to argue that the federal courts should not interfere because the controversial directives had not yet been fully implemented across the government. This is an incredibly dangerous and legally bankrupt philosophy. It essentially suggests that the executive branch should be allowed to issue wildly unconstitutional orders, wave them as existential threats over the heads of private citizens, and the courts must passively wait until the financial and reputational damage is fully realized before stepping in to stop it. The chilling effect alone is more than enough to warrant immediate judicial intervention. That imminent threat of destruction is exactly why the four brave firms initiated their lawsuits before the orders could decimate their operations. The sheer length of the document, coming in at exactly 97 pages, is a classic, transparent legal tactic utilized when the core argument is fundamentally weak. When attorneys lack a solid constitutional foundation to stand upon, they frequently compensate by drowning the court in excessive pages, repetitive grievances, and convoluted logic. It is a desperate, calculated attempt to create the grand illusion of substance where absolutely none exists. A truly strong, constitutionally sound legal position can almost always be articulated clearly and concisely. The sprawling, breathless nature of this filing acts as a massive textual smokescreen, perfectly designed to obscure the simple, underlying fact that the administration was caught blatantly abusing its power. Every single attorney who voluntarily attached their name to this filing permanently compromised their professional integrity. They consciously chose to act as willing enablers of authoritarian behavior rather than steadfast defenders of the Constitution. This dramatic shift creates a highly toxic culture within the broader legal profession. When the highest law enforcement agency in the country actively normalizes the use of frivolous, politically motivated arguments in federal court, it sets a disastrous, cascading example for every other legal practitioner in the nation. It broadcasts a terrifying signal that loyalty to an individual leader completely supersedes loyalty to the established rule of law. This specific filing will undoubtedly be studied in law schools for decades to come, not as a brilliant, innovative legal strategy, but as a dark cautionary tale. It serves as a stark, permanent reminder of exactly how quickly democratic institutions can be eroded from the inside when the highly educated people entrusted to protect those institutions decide to simply look the other way. The arguments presented in these 97 pages are not just legally bankrupt, they are structurally dangerous to the very survival of a free and open society. If the federal courts had actually accepted the terrifying premise that the president is entirely shielded from all judicial review when issuing vindictive, retaliatory directives, the fundamental balance of power in the republic would have been permanently shattered. The boldest, most arrogant claim within the text, the assertion that the judiciary cannot tell the president what to say or what not to say, fundamentally misrepresents the entire nature of the lawsuits. The courts were never attempting to censor the personal speech or the opinions of the executive. They were directly halting official government actions, carried out through formal executive orders, that carried severe, tangible, punitive consequences for private entities. There is a massive, undeniable difference between a politician voicing a harsh opinion and a president wielding the immense, crushing weight of the federal bureaucracy to financially ruin private citizens. Conflating these two entirely distinct concepts was a deliberate, highly deceptive strategy employed by the government attorneys to confuse the core issue and shield the administration from any meaningful accountability. The specific mechanics of this capitulation require intense scrutiny because the language utilized in the official documents actively conceals the true horror of the situation. The government proudly stated that 9 prominent institutions agreed to address their internal practices and commit to providing free legal work in the public interest. That carefully sanitized phrase is perhaps the most terrifying collection of words in the entire legal filing. It translates directly to total institutional surrender. These massive corporate entities willingly permitted the executive branch to rewrite their internal operational manuals. They allowed political operatives to dictate who they could hire, who they could represent, and exactly how they were allowed to conduct their private business. The agreement to provide free legal labor represents an entirely new, incredibly dangerous evolution of political extortion. Traditionally, free legal assistance is a noble, vital component of the justice system, specifically designed to help the marginalized, the impoverished, and the vulnerable. Forced charity was transformed into a bizarre, medieval form of tribute paid directly to the sovereign. The administration weaponized the concept of public interest, defining it strictly as whatever aligned with their immediate political goals. By agreeing to these terms, these highly educated professionals essentially accepted a plea deal for a crime they never committed, paying their fine in the form of coerced, politically motivated labor. The true catastrophe extends far beyond the humiliated boardrooms of those specific entities. Their cowardice created a massive, structural fracture in the foundation of the adversarial justice system. Independent legal counsel serves as the primary, indispensable barrier between the immense power of the state and the fundamental rights of the individual. When the most heavily fortified, fiercely protected private entities in the Republic decide to simply lower the drawbridge and surrender the castle, that protective barrier completely evaporates. If multi-billion-dollar enterprises possessing infinite resources and global influence are too terrified to endure a political fight, the everyday citizen is left entirely defenseless. This capitulation sends a devastating psychological shockwave throughout the entire legal ecosystem. Consider the perspective of a small, regional firm or an independent civil rights attorney. They watch the apex predators of their industry crumble under pressure from the executive branch. The immediate takeaway is that resisting the government is financial suicide. This generates a profound chilling effect on legal representation across the nation. The next time a controversial figure, a political dissident, or an unpopular cause requires fierce legal advocacy, the pool of willing defenders will be drastically reduced. Attorneys will quietly reject difficult cases, fearing the sudden, vindictive wrath of the federal government. The right to legal counsel becomes conditional, completely dependent on whether the administration approves of the client. Furthermore, this surrender actively drafted a comprehensive, highly effective blueprint for future authoritarianism. Tyranny rarely arrives overnight. It creeps in through small concessions, normalized abuses, and the silent complicity of those who have the power to stop it but choose not to. Dictators and autocrats are excellent students of history. They take meticulous notes on what tactics succeed and what strategies fail. By giving in to these unlawful demands, these massive institutions essentially provided a proof of concept for political coercion. They conclusively demonstrated that a leader does not need actual constitutional authority to control the private sector. The leader only needs the willingness to issue aggressive threats and the patience to wait for corporate risk managers to decide that compliance is cheaper than conflict. Future administrations, regardless of their political affiliation, now possess a tested, successful playbook for neutralizing private opposition. Whenever a future executive faces resistance from the corporate world or the legal sector, they will immediately remember the exact moment 9 of the most powerful institutions on earth folded without a single objection. They will utilize the exact same threats of contract cancellation and security clearance revocation, knowing with absolute certainty that the strategy works. The damage inflicted by this cowardice is entirely generational. We entrust the most elite members of the legal profession to act as the ultimate guardians of the Constitution. They are granted immense societal privileges, substantial wealth, and significant influence strictly under the assumption that they will fiercely defend the rule of law when it is directly threatened. In the defining moment of their professional existence, when the Republic required their strength the most, they completely abandoned their posts. They traded the foundational principles of American justice for short-term institutional comfort and the preservation of their government contracts. They preserved their revenue streams, but they permanently bankrupted their moral authority, leaving the entire democratic system profoundly vulnerable to the next inevitable attack. The survival of a functioning constitutional republic relies entirely on the courage of individuals and institutions willing to defend it during moments of intense crisis. The stark contrast presented in this single court filing serves as a profound historical lesson regarding the absolute necessity of judicial independence. When the immense, intimidating weight of the executive branch is weaponized to crush private opposition, the courts remain the final, critical barrier protecting the American people from absolute tyranny. That barrier only holds firm if independent advocates are willing to stand before a judge and argue the law without fear of personal or professional destruction. We must return our focus to the four institutions that successfully held that line. Perkins Coie, Jenner, and Block, Wilmer Cutler Pickering Hale and Dorr, and Sussman Godfrey did not merely win a localized contractual dispute. They actively defended the fundamental right of every citizen to seek legal counsel without the government dictating the terms of that representation. Their victory ensures that the justice system remains an adversarial arena where facts and constitutional principles outweigh the vindictive impulses of any political leader. They demonstrated that the highest office in the land is not immune to accountability, and that the bedrock principles of the nation cannot be simply overridden by an angry executive directive. This entire ordeal underscores a terrifying reality about the fragility of democratic norms. A constitution is ultimately just a piece of paper unless living, breathing professionals are willing to enforce the words written upon it. The ethical obligations of the legal profession extend far beyond maximizing corporate profits or securing lucrative government contracts. Lawyers take a sworn oath to support and defend the Constitution. When that oath is tested by an authoritarian threat, the true measure of a legal professional is revealed. The four firms that fought back honored that sacred commitment, proving that integrity can actually defeat intimidation. We are living in an era where the fundamental pillars of our legal system are constantly being tested by those seeking unchecked authority. Defending these institutions requires an informed, fiercely engaged public to recognize these overreaches and hold the powerful accountable in the court of public opinion. I am incredibly curious to hear your personal thoughts on this unprecedented legal battle. Do you believe the 9 firms that surrendered should face long-term professional consequences, or do you think they were simply making a pragmatic business decision to survive a hostile administration? Please leave your detailed opinions in the comments section below because this conversation is absolutely vital for the future of our country. If you found this deep dive into the harsh realities of our justice system valuable, please take a moment to share this video with your friends, your family members, and across your social media networks. Spreading awareness is the single most effective way to combat political overreach and protect our institutions. Please remember to subscribe to United States News Daily and interact with the channel so we can continue bringing you these critical